This pandemic has changed the world. Margaret W. Wong and Associates, with over 40 years experience in U.S. immigration law, keeps working for you in the midst of adversity. Offices are in Cleveland, New York, Memphis, Atlanta, Columbus, Raleigh, North Carolina, Nashville, Chicago, and Minneapolis. Look after your loved ones and we'll take care of your immigration needs. Please call us at 216-279-3984. That's 216-279-3984.
Hello, everybody. Thank you for joining us today. Welcome to this show. This is a question and answer show with one of the most important attorneys in the law firm of Margaret W. Wong and Associates, which is located in 9 cities of the United States and has been working for over 40 years in this immigration field. So please feel free to ask your question. We will be here taking care of each one of them. And the attorney, Francis Fonsang, will be with us in this afternoon. Hello, Attorney Francis. How are you doing today? Thank you for joining us.
I'm doing well, thanks. Thanks for having me.
Thank you so much, Attorney. And well, today, let's start with some questions that people have around the situation in the southern border. However, this is a person that has been detained for almost 2 months, and he has not received a bond offer or court, and he doesn't know if he has to hire an attorney or what's going to happen to him, because he has been waiting there in Arizona for 2 months already.
Well, one consideration is whether he has been deported before in the past, or whether this is the first time he's been detained by immigration. Okay? If he's been deported before, then the Immigration Service can use that old deportation order against him unless he can show a reasonable fear that he would be harmed or threatened if he goes back to his country. If this is the first time he's been detained or put into deportation proceedings, then he might be eligible for bond. He can request bond from the Immigration Service, ICE or CBP, and if they say no, they can ask for bond from an immigration judge. And if he can't do that, then he should have an attorney try to push for a bond hearing with the judge.
Is that something that usually happens, that people can stay stuck for 2 months there in jail without receiving a bond?
Well, especially during the pandemic when some of these courts were closed, it might have taken longer to get a bond hearing, but it's pretty unusual to stay for 2 months unless there's something else going on. Maybe he has a criminal record that makes him what's called mandatory detention. That means he's not eligible for bond. Maybe he is subject to an old deportation order, so he's not eligible for bond. It just depends on his particular situation.
Thank you so much, Attorney Francis. So the next question we have right now is, I was victim in April 27th of 2019. Someone beat me harder in a gas station. I was hospitalized. He beat me with a baseball bat. And I have applied for asylum in 2015. And the case is still pending. Can I still apply for Uvisa? And recently I married with a woman that she was divorced in 2019, but she doesn't have any status. Is there any chance for both? And any way you can suggest and help us? Thank you.
Okay. So just because you have a pending asylum case does not mean that you can't apply for any other type of immigration benefit or application. So if you have a pending asylum, you can also apply for the U visa if you are eligible. Now, if you were beaten, assault is on the list of qualifying crimes for U visa. And if you assisted in the investigation or willing to assist in the investigation, and the police department is willing to sign the Form 918 Supplement B, then you can apply for the U visa. Since you are now married your spouse can also apply for the U visa with you. So you can include both together on the same application, okay? And the spouse will be included as a supplement A.
Okay, I'm sorry, Attorney Francis. I can hear you, but let me connect again. Okay. I'm sorry, I ran out of battery here in my computer. Can you hear me now?
Yes, yes.
Okay, thank you so much. We just have to switch technology right here in the studio. So thank you so much for this answer. And this is a very interesting question, but please make sure that you can call the attorney to the office of the attorney Margaret W. Wong, and the attorney Francis Fonseng today is helping us get some answers. And as he said, that the fact that you have a pending asylum does not restrict you from applying for this other possibility, as long as it's you can prove what's going on. So please give us a call, 216-279-3984, 216-279-3984. The next question we have coming in is Hayendra Patel. My name is Hayendra Patel. I applied for a Uvisa last year and I got the biometrics too already, but I am on OPT and I'm going to apply for 24 months STEM OPT extension next week. So my question is, what can I do? Do I apply for the 24 months OPT extension and Uvisa EAD too? Interesting question.
So this is similar to the last question. You can have multiple applications pending with the Immigration Service at the same time. Now, just because you are an F1 OPT, which is called Optional Practical Training, which is a 1-year work permit that you can get after you graduate as an international student, if you want to maintain your student status, the F1 status, you have to make sure they actually use that OPT work permit. You find a job that's related to your major, and you actually work for an employer using that OPT. Now, you can extend that OPT for an additional 2 years if your field is in a STEM field. That means science, technology, engineering, and mathematics. So if you want to maintain your student status, definitely apply for the 24-month OPT extension. And if your employer is registered with E-Verify, which is required for the STEM extension, then you can apply. Now, just because you have a pending U visa doesn't mean that you can't apply for the STEM extension. So our recommendation is always maintain your legal status. Now, you can also apply for the U visa EAD, because you might have heard that starting now, as of this week, the Immigration Service will start approving EADs if you have a pending U visa application, if they find a bona fide determination. That means, did you file a U visa application with a signed supplement B from law enforcement or the police, with a personal statement from the victim, and have you done your biometrics? Then you'll be eventually eligible for an EAD, even though your visa is still pending. Now, we don't know how long that's going to take, so definitely apply for your STEM extension so you can continue to work and maintain your F1 status.
Thank you so much, Attorney Francis. And by the way, talking about this U visa EAD, if this person is waiting for a few months, can this person actually apply for the EAD based on the U visa?
So if you already applied for the U visa and included the form I-765, that's the EAD application, you do not have to do anything. If the Immigration Service finds a bona fide determination, then they will approve the EAD and mail it to you. You don't have to take action. If you did not file an I-765 with the U visa, then wait for the Immigration Service to make the determination. They will mail you a letter saying that you are eligible to apply for an EAD. Then you can submit the EAD application. Okay?
Okay, thank you so much, Attorney Francis. And don't forget, the phone number is 216-279-3984. 216-279-3984 is in the phone number in the main office of the attorney Margaret W. Wong, who has many attorneys working with her and for her, and of course working for you. So please, if you have any questions, if you need more information, give us a call. 216-279-3984. 9 offices in the United States: Atlanta, Chicago, Columbus, Cleveland, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And it's just one phone number: 216-279-3984. 216-279-3984. Next question, Attorney Francis. How long does it take for husband to sponsor a wife? Husband is citizen, got married with a green card, but upgraded in January to citizen. Thank you so much.
Okay, so it depends on what green card process we are going through. If this is a standard marriage case and the wife came into the United States legally, that means with the visa, was inspected by immigration at the airport or at the border, then the US citizen husband can file for the wife in the United States, and they can be interviewed for the green card in the United States. How long will that take? It depends on what city that they're living in, because it's the local office, the local immigration office, that will schedule the interview. If it's a bigger city, it might take longer to get that interview. For example, here in Cleveland, we can probably get the interview within 6 months, okay? And then after the interview, if there's no problems, then the green card can be approved. Now, if the wife did not come into the United States legally, she entered the United States without inspection, just crossing the border, then she might not be eligible to apply for the green card in the United States. She might have to go overseas to apply for the visa at the US consulate or embassy in her home country. And if she does that, then she will probably need a waiver, an I-601, to forgive all that illegal time in the United States. If we need to do an I-601 or a 601A, then that process could take 2.5 years, because first we need to get the marriage petition approved. Then we have to get the I-601A approved. And then we have to get the interview scheduled at the US Embassy. All of that could take 2.5 years or longer.
Thank you so much, Attorney Francis. And we have a lot of questions coming in today, and related, many of them related to the Uvisa. I think it's on the news and everybody's talking about it. So this next question we have is, I applied for Uvisa 4 years ago when I heard in the news about the EAD. I have the 3 requirements: fingerprints, sign form, and personal statement. What do I need to do now?
Okay, so you applied for the EU visa 4 years ago. The good news is you're probably going to get a decision pretty soon. The Immigration Service is taking between 4 to 5 years to process EU visas, okay? Now, if you did submit an EAD application, the form I-765, with your EU visa, then you don't have to do anything. The Immigration Service will make the determination on its own to see if you qualify for the early EAD, and if you do, they will approve and mail that EAD directly to you. If you have not submitted an I-765 with your EU visa application, then the question now is, what do you do? The Immigration Service has said that they will analyze each case and send you a letter if you are eligible for the pending EAD. What you could do is you could file the I-765 now, but that might slow the case down because you don't have that letter from immigration saying that you are eligible. So what I would recommend is just wait for now, see what the Immigration Service does.
Thank you so much, Attorney Francis. And well, now we have a couple more questions, but I think they are already answered by you. And thank you so much for these answers, Attorney Francis. We have a different question right now. I applied for, my husband applied for me. He's an U.S. citizen, and I've been here for 17 years. He applied for me, and we did the application 2 years ago. Um, I filed the I-130. It was approved, and I am going through the waiver. And now they say that he cannot sponsor me because of the income. I did the I-864, and I put that he was earning $22,000 per year, and they said that he cannot sponsor me. And I see the numbers are 19,000 or 15,000, but I don't understand why he cannot sponsor me. How can I do now? Do I need to get a joint sponsor? Thank you.
Okay. So it sounds like you are at the very end of the process. You've already done the hard part. I-130 is approved. The I-601A is approved. Now you are applying for the visa and scheduling the interview at the U.S. Embassy in your country. Now, when you're submitting the visa application documents, you need to submit the Form I-864, which is the affidavit of financial support, to show that the sponsor can support you financially if necessary. Now, how much money does the sponsor have to make? It depends on what's called the household size. How many people is the husband supporting financially right now? And so usually we look at the tax return. Who is included as a dependent in the husband's tax return? If it's just the two of you, the husband and the wife, then it's a household size of 2. And I believe that $22,000 should be enough. But if there's another relative, a dependent on the tax return, it could be a child from a previous relationship. It could be a niece or a nephew, it could be a parent. If there's other people on the tax return, that increases the household size, and that would increase the amount of money the husband has to make. If he does not make enough money, then you do need a joint sponsor. It has to be a US citizen or green card holder. Could be a friend, could be a relative, okay? And that sponsor would have to make enough money, including that person's household size, plus one more person, you, okay?
Okay, thank you so much. That was very, very clear. So I appreciate that answer. If you have more questions, please call 216-279-3984, 216-279-3984. I'm pretty sure that they will have the answers for you. And some people are really smart and they can try to do the filings by themselves. But then when something happens like this, they get stuck. And then you need to talk to an attorney, and maybe you waste a lot of time just waiting on something that you didn't know that was going to come up. So that's why you need an attorney to do this kind of cases or this kind of filings, so that you know that it's going to go straight down the road, and you will get your immigration relief as soon as possible. Okay, so we have a lot more questions asking about the Uvisa EAD, Attorney Francis. But I think we are already clear with this question, or is there anything else that you can add? Because this person is asking, so as per the new Uvisa EAD rules, if we already applied for Uvisa, then we don't have to take any action now?
Correct. If you already applied for the U visa, you already submitted the EAD application with your U visa, which most people do, then you don't have to take any action now.
Okay, and this same person is asking, so what can I do if I get U visa EAD and OPT EAD?
Okay, just because you get the U visa EAD does not mean you have to use it. So by using it, I mean when you go to work, you have to show your employer that you're eligible to work. You show a social security card, you show the EAD, you show a driver's license. Now, just because you get the U visa EAD does not mean you have to actually use it. If you already have the OPT EAD and you want to maintain your F1 student status, then use the OPT EAD. When you're working, you show the OPT EAD, do not show the U visa EAD. If you don't use the U visa EAD, then you are maintaining your OPT status. Okay.
Okay, thank you so much, Attorney Francis. And okay, so now we have investment visa question that is very interesting. I have sent a lot of information. I have TV production company in Colombia, and I also have a farm that we raise porks. So I would like to go to the United States and see if I can invest in one of those two businesses. And I would like to know what are the requirements and how much do I need to invest in order to get my investment visa.
Okay. Well, congratulations. The Colombia should qualify for what's called an E2 investor visa. E2 is a temporary work visa that you can apply for if you invest into a US business and you want to come to the United States to manage that business. Okay, so what are the requirements? First, you have to make a substantial investment. That means the amount of money. There's no minimum requirement, but usually we recommend at least 100,000 US dollars. Okay, the money has to be put at risk. That means the money can't just be sitting in your bank account. You have to have invested the money already. So either you've purchased the land, or you've bought the shares in the new business, or you've purchased the inventory. So it's already at risk. The money is transferred. You have to own at least 51% of the new business. So you have to be the principal owner. Okay. And also, it has to be a US business. So that means that it's not just a theoretical business that you're thinking about. It has to be far enough along that it could be a startup, which means you're starting a new business, but that means you have to have a location, it has to be a business plan, you have to open a bank account, and you have to be ready to actually start business, potential customers. Or if you're buying an existing business, you can just show that the business is already existing, it has employees, it's got sales and customers. Okay, you submit this E2 visa application to the US Embassy, and if they find that you're eligible, then they will allow you to schedule an interview at the embassy.
Thank you so much, Attorney Francis. The phone number, don't forget, is 216-279-3984, 216-279-3984. So we have another person asking a question here. I have a question. My husband applied for cancellation of removal. Even his case is not with immigration judge. He came here 10 years ago and never went back. I don't really understand the question. Maybe you do.
Well, I mean, I don't hear a question in there, but so it could be that this person applied for, if you're in removal proceedings, that means you're in immigration court, subject to deportation, and you have a pending case with the judge. If you've been in the United States for at least 10 years, you're a person of good moral character during those 10 years. That means no serious criminal record. And you have a parent, a spouse, or a child who's a US citizen or a green card holder who would have extreme hardship if you had to leave the United States. Then you can apply for the green card with the judge, and that's called cancellation of removal or 10-year cancellation. Now, a couple years ago, during the Obama administration, the court was administratively closing a lot of these cases. That means temporarily closing the cases, putting them on the shelf so that you don't have to go to court, but the case is still pending, so you can keep renewing the EAD, the work permit, based on that pending cancellation case. And so it's up to the discretion of ICE, immigration, to determine, are you eligible for this administrative closure? Now, over the past couple of years with the previous administration, the Trump presidency, a lot of these cases were recalendared and put back onto the court docket or calendar. And so those cases were reopened. So this could be a situation where the case is still closed and you can keep renewing the work permit, or maybe it's going to be reopened. We just don't know. I think we need more information.
Okay, thank you so much for trying to answer this question that actually was not a question, was something that we tried to understand. So this question that we have here is very interesting. I just lost it. Let me check here. Okay. So, hi, attorney. My question: my mom is a citizen of the United States, but due to her age, for the last 4 years living in India with an attendant and my sister, the attendant understands her language and our culture is so it's easy. My sister's situation is changing, so I am bringing my mom back to the United States to live with me. Will I be able to bring her attendant with her? Will she get the visa? It will only be for a few months. Then they will both go back to India. Will she get a visitor visa for 6 months, or is it possible for her to get another kind of visa or permit? Thank you.
Okay, so there's two options for this person. One is just a regular visitor visa, a tourist visa. If you want to come visit the United States, you apply for a tourist visa at the embassy, you go to an interview at the embassy, and then they either approve or deny the visa. It's usually very quick. The interview is only maybe 3-4 minutes long, okay? A lot of people want to come visit the United States from India, so it could be very difficult for her to get this visa, but she can try. The second type is still a tourist visa, but it is for what's called domestic workers, and that is a B1 instead of a regular B2 tourist visa. It's domestic workers for B1, and what those type of visas are for domestic workers, people who work in the household of a U.S. citizen or a temporary visa holder to come to the United States temporarily to help take care of that household while that U.S. citizen or temporary visa holder or family is in the United States. And then after that visit is over, everybody goes back overseas to continue their life overseas. Now, a lot of the times this is for expats. That means a U.S. citizen is working overseas for a company, has a local domestic worker working for the family. The U.S. citizen has to come back to the United States temporarily before going back for the job. And so they bring the domestic worker to the United States so that they can take care of the family in the United States during this temporary visit. Now, you can try one or both options, but you would have to show that this visit in the United States is temporary in nature. So if the mother is elderly, she might be staying in the United States permanently, then it might be difficult for this worker, this person, to get a domestic worker visa. Maybe she should try for the regular tourist visa first.
Okay, thank you so much. Yeah, this is a very interesting question, and maybe will the United States think that this person will be working here in the United States? That I think it could be another issue. This next question is interesting as well. My dad applied for me, and we are so sorry for your loss to this person that is writing to us. But he passed away 3 days ago. I am in Brazil. Does my case stop, or somehow I can continue the case?
All right, well, I'm sorry for your loss as well. Since your dad filed for you, but he passed away, ordinarily that means that the petition is canceled. It's gone. But there's what's called humanitarian reinstatement. You can save that petition if you apply for humanitarian reinstatement with the Immigration Service and show why you should be able to continue the case and immigrate to the United States. So you can talk about hardship to the family in the United States if you can't come. You can talk about your personal situation in Brazil. What would happen to you if you can't come? And because there's also that I-864, the financial support requirement, because your father can no longer sign that I-864, there has to be a substitute sponsor, another relative in the United States. It could be a brother, it could be a sister, it could be an in-law, it could be a child, it could be another parent, and some other relative in the United States who can be that substitute financial sponsor. So this is not the end. You can apply for humanitarian reinstatement.
Does it change the situation if the I-130 was approved or not?
It should not, but it has to be approvable. That means that if this was not actually your father, or there's a problem with the petition, then you might not be able to get reinstatement. So immigration still has to approve that petition before they can reinstate it.
Okay. Thank you so much, Attorney Francis. And well, our time is up. So thank you so much for all these awesome answers. I'm really happy every time that we finish this show because I learn a lot from you, Attorney. So thank you so much for being so clear for answering each one of the questions. So have a good weekend. It starts tomorrow, and see you next week.
All right, you too.
Thank you so much. So please, for everybody who joined us today, don't forget to call to the office of the attorney Margaret W. Wong, who started this office out of nothing, out of just she started working with one desk and no secretary in 1977, and now is one of the most important law firms in the United States with 9 offices in the different cities. In Cleveland, where is the headquarters office, Atlanta, Chicago, Columbus, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is just one phone number, 216-279-3984, 216-279-3984. There is no case that the law firm cannot work, study, and see if they can resolve it for you, no matter where you are. They can help you get a relief in your immigration status and also represent you in the immigration court. Call right now, 216-279-3984, 216-279-3984. See you next time. Take care. Please take care of yourself. Stay safe. If you haven't got the vaccine, go get the vaccine. We're getting out of this bad situation of the quarantine and also the pandemic, but we still need to be careful. We still need to take care of ourselves, and don't be afraid about the vaccine. Please go get the vaccine. And that's why the office is opening again. It's we're doing in-person consultations in different cities of the United States. This week was Nashville and Chicago, and people were really happy because it's always good to be able to talk person to person with your attorney. 216-279-3984, 216-279-3984, the office of the attorney Margaret W. Wong. Thank you, and see you next time.
This pandemic has changed the world. Margaret W. Wong and Associates, with over 40 years experience in U.S. immigration law, keeps working for you in the midst of adversity. Offices are in Cleveland, New York, Memphis, Atlanta, Columbus, Raleigh, North Carolina, Nashville, Chicago, and Minneapolis. Look after your loved ones and we'll take care of your immigration needs. Please call us at 216-279-3984. That's 216-279-3984.